Welcome to Washington and Lee University Law School's conference, False Confessions, the True Story. If you're here for the conference on Admiralty Law, it is down the hall. You're really in the wrong place. I'm going to talk as fast as I can because there's so much to be said, and I just want to get to it. I want to first give my deep thanks to this wonderful law school, to our dean, Nora Demleitner, who's here, the Francis Lewis Law Center, and Professor Ben Spencer for their support, and to Maisie Osteen and Wendy Rice, who are there, who are largely responsible for the success of this, and to an astounding array of student organizations who thought this issue important enough to help make this conference happen. They're all listed on page 2 of the program. This day threatens to be the mother of all conferences. It is highly substantive, gripping, emotional, and more than anything, as I said last night, for those of you who were not here, it shines a light onto one of the most disturbing corners of the criminal justice system. The Innocence Project reports that there have been approximately 310, 11, 12 DNA exonerations to date. More seem to show up every day. Of those, 25% involve false confessions. In other words, an astounding number of people confessed to doing the most horrendous things who were absolutely innocent. I also said last night that there were many other dark corners in the criminal justice system. I named a few: eyewitness identification, purchased testimony, pressures to plead guilty. Those are each for a conference on another day. Today, the light is going to shine on this phenomenon of false confessions. Why do the innocent falsely confess? What are the police practices which encourage that? What's the psychology which comes to bear? Why are the young so susceptible? How do you go about attacking a false confession? And how do you help restore the lives of those who have been locked away for years for crimes they did not commit? Like the two men we're honored to have here with us today, Eric Wilson and Raymond Santana. All right, enough. We have all-stars with us today. Our first group will share some of the research on false confessions, describe two of the most well-known cases in this sort, corner of the system, Mr. Santana's case, Mr. Wilson's case. Let me tell you who's here. First, Steve Drizin, an assistant dean and a professor of law. Excuse me, at Northwestern University. Go Cats. Steve was the co-founder of the Center on Wrongful Convictions of Youth at Northwestern. He's been a formidable writer, researcher, and teacher, and lawyer, and general go-to guy in the field. You'll see an incredible article that he co-authored in the materials, which are all online as of this morning, and you ought to check them out. The Problem of False Confessions in a Post-DNA World, Steve's work. He worked with our very own David Bruck on the horrible Cope case, which is ongoing. Steve also won the ABA's Livingston Hall Award for outstanding dedication and advocacy in the juvenile justice field. I don't have time to give you the full lowdown. You get the idea. He's an all-star. Steve Norfolk is here today at the end of the table. Steve is a personal hero of mine, retired partner from Troutman Sanders. How this guy who did commercial litigation for years ended up on this platform is going to be an interesting story. He has been a tireless fighter for justice. He ran the pro bono program at Troutman for 10 years. That's where I first met him. Steve roped me into being an expert in one of his successful attacks on a wrongful conviction. Steve was awarded Virginia State Bar's Lewis F. Powell Pro Bono Award, and astoundingly, so was another guest of ours who you'll hear from later this morning. Steve also won the Richmond Bar's John C. Kenney's Pro Bono Award. He's the executive director of the Virginians for Alternatives to the Death Penalty. He's on the board of the Mid-Atlantic Innocence Project. He represents Eric Wilson in his ongoing epic battle with Virginia. And in just the last day or two, Steve was successful in getting the U.S. Navy to finally upgrade Eric's discharge to honorable. Brandon Garrett is here today. We are very pleased that we were able to coerce Brandon to join us. Brandon is a professor of law at some law school in Charlottesville. He is well known as a teacher, researcher, and writer in the field of wrongful convictions. His book, Convicting the Innocent: Where Criminal Prosecutions Go Wrong, received both the American Bar Association's Silver Gavel Award as well as a Constitutional Commentary Award. His work's been cited by the United States Supreme Court and other courts, and interestingly, as a young lawyer, not so long ago, he worked for a time on Mr. Santana's case. And joining them will, of course, be Eric Wilson and Raymond Santana. I met Eric and his wife, Misty, just 2 nights ago, and Raymond for the first time last night. You have to wonder how these two men not only endured, but are both successful and seem to be not the least bit bitter. Eric was just a young sailor when he was ensnared. Raymond was 14 years old when he was convicted. Both spent years in prison, bad enough, all would agree, but with the added torture of knowing that they were innocent men, and with the added torture of having most of the world believe that since they confessed, they were in fact guilty. Both have been exonerated, although for both the legal burdens continue. Eric, though proven innocent, has been denied a pardon. Though innocent, he is compelled to register as a sex offender. Raymond, though proven innocent, has been struggling in court for years against an intransigent New York City for compensation for the torture he endured. And both have traveled long distances to be here, and we are grateful for that. Welcome. And I will now turn this over to Steve Drizzen. We have a short clip to show you first.
What happened that day? And be horrified by ourselves. New York in the late 1980s was a completely schizophrenic, divided city.
New York's now the capital of racial violence.
Criminality, gang wars, drug wars. We were supposed to be afraid. It would have been irrational not to be afraid.
Off with the camera!
Last night, a woman jogger was found unconscious and partially clothed in Central Park. She was beaten and sexually assaulted.
A woman jogging in Central Park. Central Park was holy. It was the crime of the century.
5 youths were arrested at 96th Street, all between 14 and 15 years of age.
You can only imagine the pressure to have this crime solved and solved quickly.
First we was all together, then they started to put us in different rooms, separately. What did you do? Who were you with? Who did you come with?
The tone was very scary. I felt like they might take us to the back of the precinct and kill us.
Never go home until you give up the story.
I told my son, go to the park that night. I feel guilty. I'm telling the guy, I don't know what you're talking about. They're getting a little angry. And they're like, you know you did it, didn't you?
He had been interrogated for over 24 hours. That amounts to pressure.
These young men were guilty. It was almost unquestioned. The police controlled the story. They created the story.
They seized on the fears of the people, wilding the bestial characterization of the black man.
There's no DNA match whatsoever to any of these boys.
I was going nuts. No blood on the kids. Nobody could identify them, but if they confessed, and that was that.
A lot of people didn't do their jobs. Reporters, police, prosecutors, defense lawyers. This was institutional protectionism.
We falsely convicted him, and we walked away from our crime.
This is the ultimate siren that says none of us is safe.
Next time on Frontline, 4 confessions.
I grabbed Michelle.
Forced her to have intercourse.
I was in her.
I stabbed her. 4 men.
He got me to confess.
I broke and told them whatever they wanted to hear.
1 case
4 people interrogated coercively,
that cracks open the justice system.
confessed to a crime they didn't commit. Forget the truth. Forget justice.
The Confessions. Watch online or on air beginning November 9th.
Good morning. It's a real honor and pleasure for me to be here in Lexington among so many of the critical people involved in the work on false confessions. And I want to thank Steve and everybody else, Jonathan and everybody else for bringing this here. So some people collect stamps, some people collect coins. My daughter collects Beanie Babies, my son collects baseball cards, and I collect false confessions. And I've been doing it for about 15 years. And we're going to talk today about some of the confessions that are in my database. But more generally, I'm going to give you an overview of the problem of false confessions. And throughout the day, we're going to deal with very important issues concerning false confessions and how to represent people who you believe have falsely confessed. Let's see. Okay. So, generally, it's important to recognize that today there's no longer the third degree in the United States. There are a few exceptions, like my hometown of Chicago, where police still torture suspects. But by and large today, it's psychological tactics that are the cause of false confessions. This is a highly debated issue in the police world because police officers are trained that their tactics are not apt to produce false confessions. And you have living, breathing proof right here, in fact, that they do. We found hundreds of documented police-induced false confession cases. Richard Leo and I wrote an article about 125 of them in 2004. We now have a database that is over 300 proven false confessions. As was said earlier, 16 to 20% of the DNA database involve false confessions. What's important to know is that, and it's even more counterintuitive, is that most of the false confessions in the data set are to murders, crimes that can bring someone to death penalty or life without parole. And many of those confessions are to murders of loved ones, perhaps the most unimaginable of all crimes. In fact, if you look at the homicide-only cases in the DNA data set, false confessions outnumber eyewitness identifications by 2 to 1. One of the things that Professor Garrett is going to talk about that surprised him and surprised us when we started looking at the substance of these false confessions is that they're highly detailed and they're chock full of details that only the true perpetrator would know. And the question that raises is, how does an innocent person who has nothing to do with the crime know the details that give that confession the ring of truth? And the answer is, he's fed them by police officers over hours and hours of unrecorded interrogations in a process known as contamination. It's also important to know that false confessions do not only come from vulnerable suspects. Eric Wilson is not considered a vulnerable suspect. Raymond Santana was 14. That's a vulnerability. But these are highly intelligent young people who falsely confess to crimes they didn't commit. While the length of an interrogation is a risk factor, clearly the longer the interrogation, the easier it is to break someone down to a place of hopelessness where you can manipulate them into confessing. It's not true that shorter interrogations don't produce false confessions. Everybody has a breaking point, and some people have breaking points that are much lower than others. And at a certain point in time, a suspect, even after only an hour or two, may decide that the stress of this process is so great that he has to bring it to an end. And if confessing is the way to bring it to an end, he or she will confess. False confession can trump DNA and can corrupt other evidence. We know that to be the case in both of our men who are going to speak about their cases later. In Raymond's case, there was a DNA exclusion at the beginning of the case. And in Eric's case, it's one of the few cases, there's only 3 that I know of, where DNA not only excluded him prior to trial, but matched the true perpetrator. And prosecutors then went forward under some half-baked conspiracy theory in order to get conviction of everybody. They accommodated the DNA evidence. And they sold a story to a jury that was swayed by the power of confession evidence. The other case is Billy Wayne Cope's case, which Professor Bruck and I are working on. And the third case comes from abroad. It's the Amanda Knox case, who woke up this morning learning that she was yet again convicted of a crime that was committed by Rudy Gaudet. When I say it can corrupt other evidence, what I mean by that is also that if a scientist, if a fingerprint examiner, if a blood examiner, if a polygraph examiner knows that there is a confession from the suspect that he's examining, they oftentimes will taint their findings to accommodate the confession. They will see things that don't exist, like fingerprint matches. So it's that powerful. And it's not uncommon for there to be multiple false confessions in the same case. The Central Park 5, the Norfolk 4, the Beatrice 6. In Chicago now we're working on a case with 7 false confessions in the same case. Once you get one confession, it's like a house of cards, and that confession is used to batter and persuade other suspects to confess to crimes they didn't commit. And that's the wrong direction. Okay. I'm not going to spend too much time on the Central Park jogger case, but essentially in April of 1989, a female jogger was running through the park on the 102nd Street transverse in the northern reaches of the park when she was hit from behind, dragged into the woods, sexually assaulted, and left for dead. Police had been called to the park earlier because there were some other incidents in the park involving a roving group of boys who were harassing joggers and cyclists in the park. They had arrested and detained a number of those boys, and they were starting to release them. In fact, they had released some of them when the jogger's body had been located about 1 o'clock in the morning. And all of a sudden, the case took a dramatic turn because somebody in the police department jumped to the conclusion that the boys who were involved in the assaults on the bikers in different parts of the park must have been involved in the assault on the jogger. After hours of interrogations that spanned over 2 days, They emerged with 5 confessions to the assault on the jogger. 4 of them they managed to get on videotape after the hours of interrogation. 1 was an oral confession. Before trial, the magic moment, DNA excluded all of the defendants. That should have been a warning sign to prosecutors that maybe they had the wrong people, but it wasn't. They went forward under the theory that there must have been one who got away. There also was some forensic evidence found on Kevin Richardson that they claimed was hair evidence that was consistent with the evidence, the hair of the jogger. All 5 defendants were convicted, were sentenced to between 5 and 13 years in prison, until this man emerged, the East Side Slasher, one of the most infamous rapists and killers in New York, a man named Matthias Reyes. His DNA matched the semen stains that were found on the jogger's socks. The DNA testing that was done on the hair that was on Kevin Richardson proved that it did not belong to the jogger, and he knew facts that none of the other boys knew. He knew about her Walkman, he had stolen her headphones, he knew what he hit her with, he knew where he dragged her, he knew how he tied her, and the way he tied her was very similar, if not identical, to the way he tied many of his other victims. And this case should have been a wake-up call for everybody in the country, including New York. It had issues of youth, disabilities, multiple false confessions. Confession evidence may have corrupted the science with regard to hair. It caused tunnel vision. None of this happened because of the polarization that exists in New York City around this case, and because too many professionals, too many prosecutors, too many police officers, too many government officials are invested in the false narrative that these boys are somehow still involved. When I come to a town, when I come to a state, I always look in my data set for cases. And Virginia is no stranger to false confessions. In fact, the first DNA exoneration in the United States, David Vasquez, came from the city of Richmond. You see the Norfolk Four, you're going to hear about them later on today. In Windsor, a woman named Beverly Monroe, an elegant, beautiful woman, was coerced into admitting to killing her boyfriend in a crime that was a suicide. Robert Davis is a case that I'm working along with Steve and Laura, and you're going to hear more about that in a few minutes. Of course, there's Earl Washington, one of the seminal cases in the field, and there's a case that the Virginia Innocence Project is working on, University of Virginia, involving a young man named Eric Weakley out of Culpeper, the same county where Earl Washington works. These are just a few of the cases of false confessions from Virginia. The very same detective who got false confessions from the Norfolk Four got 3 teens to falsely confess to a murder in 1990. Those are the names of those teens, and here are some other cases from Virginia involving false confessions. And these are just the tip of the iceberg. There are others that I'm sure I've yet to be uncovered. In the few minutes I have remaining, I want to tell you about how we look at these cases when we autopsy these cases. We find 3 errors that are consistent in every single one of these cases: the misclassification error, the coercion error, and the contamination error. Part of the reason for the misclassification error has to do with police training. Police officers are trained by leading interrogation training firms that they can recognize deception by looking at your body language, by listening to the words that you use. And they put it all into their formula in their minds, and they can tell whether you're lying by all of these verbal and visual clues. And these are some of the clues, and it's almost laughable when you look at them. A truthful suspect is upright, a guilty suspect is retreating. Someone is slouching, someone is leaning forward. These behaviors describe basically the way my teenage children interact with all adults. Despite trying to teach them to lean forward and be engaged. They are not reliable signs of deception, and neither are these other language type clues. I swear I didn't do it. I honestly didn't do it. Those kinds of qualifiers are often the voices of desperation after hours and hours of denials have been overridden. Reed and Associates claim an 85% accuracy of detecting deception, and every study that I've ever seen shows that there's no better than a 50-50 chance that we just are terrible human lie detectors. And even if we do think someone is lying, it doesn't mean that they're lying about the crime that they're being questioned about. People lie for all kinds of reasons, including protecting others. These kinds of broad behavior and verbal clues give police officers so much wiggle room that we have cases in the false confession data set where a lack of emotional response was seen as deception. At the same time, an overly emotional response was seen as deception. So for the suspect, they can't win. It's however the interrogator views it. Other sources of misclassification are criminal profiling by law enforcement. And there are a number of cases in the database where police officers do what's called a criminal profile to try to get a sense of who the kind of person was who would have committed the crime, and they're often wrong. And Jeffrey Deskovic paid a serious price for a mistaken criminal profile of a white or Hispanic man aged 19 to 25, 5'10", intellectually slow, who knew the victim. The true killer was a stranger, African American, age 29, and over 6 feet tall. Many other sources of error in the misclassification area come from police experience. Now, police experience is valuable. I'm not saying check it at the door, but it doesn't necessarily mean that the person you are interrogating is guilty. When a child is killed within the home, someone in the family must have killed the child. There are plenty of stranger invasions in home. If there are no signs of forced entry, the killing must have been an inside job. Criminals today can get into homes with credit cards. They don't need to leave signs of forced entry. We know from the Beltway sniper killings that the police were spending weeks looking for lonely, alienated white men, and it was 2 blacks who were involved in that killing. When you play the odds based on experience, you're going to make mistakes. The coercion error is going to be talked about by Laura Nyrider in the Robert Davis interrogation, but essentially they feed on each other. So if police officers believe you're guilty, that belief colors the way they're going to interrogate you, and the interrogations are going to be more coercive, more accusatory. They're going to use more deception. They're going to use more promises of leniency, and they're going to use more threats of harm. And finally, there's the most important error, the contamination error. And why is it so important? Because when police officers feed suspects details of the crime, if the interrogation is not recorded, when the cases come into court, prosecutors always argue in opening that we know this confession is true because it has these details in it. Police officers take the stand and they say that the details came in an uninterrupted narrative without prompting or persuasion on the part of the suspect. And the same thing happens in closing argument, when in fact those details came from the police and the suspect just incorporated them into a preconceived narrative by police officers. That is the single, to my mind, biggest reason why false confessions that are wrongful arrests lead to wrongful convictions. I'm going to turn it over now to Steve Norfolk to talk about the Norfolk Four case. You're going to see these themes emerging throughout the afternoon.
Thanks, Steve. As Steve suggested, you're going to see many of the themes that he highlighted in his remarks as being among the root causes of this phenomenon. You're going to see these emerging in the cases we discussed. And they're definitely present in the case of the Norfolk Four. And I want to spend most of my time in talking about the case with you, talking about Eric and how Eric got involved. But in order to understand how Eric got involved, I really need to go back to the beginning and tell you the story of this case, because it's truly remarkable. Unlike the Central Park 5 case, where the police had these suspects, these 5 young men, and virtually simultaneously they got all of them to confess. In the Norfolk Four case, the 4 confessions that the police got occurred over more than a year's period of time. And they occurred seriatim, one after the other. And as the confessions were obtained, the police kept altering their theory of the crime and how it occurred. So the story starts on July 8th, 1997. Billy Bosco was a young sailor. He had been on a ship away, and he came home that morning to his apartment in an apartment complex in Norfolk, Virginia. Norfolk, Virginia is a very military town, lots of sailors. And he comes into his apartment and finds his 18-year-old wife, Michelle, dead on the floor of their apartment. She had been stabbed multiple times. It turned out with a steak knife, and it turned out she had also been raped. Not surprisingly, given Norfolk and what a military town it is, this was almost immediately a high-profile case. Lots of news coverage. There was a lot of pressure on the police to solve it, solve the crime. In hindsight, very unfortunately, the lead homicide detective for the City of Norfolk Police, Robert Glenn Ford, was assigned to investigate the case. And he went to work and pretty quickly developed a lead to a neighbor of Michelle and Billy's, a young sailor named Daniel Williams. The police approached this case under the assumption that this was probably a single perpetrator case committed by someone who knew the victim. The reasons included the fact that there was no sign of forced entry, so they thought that the victim probably knew her assailant. And the apartment was quite small, and there were papers and other items in the apartment, none of which had been disturbed in any way. So that seemed to rule out a group of people being involved in the crime. So Ford brings Dan Williams in for an interrogation. He lived in the same apartment complex with, as it turned out, his young wife who was dying of cancer. They bring Dan Williams in. He underwent an all-night interrogation session with Ford and a partner of Ford's, none of which, of course, was recorded. And at the end of that session, Dan Williams gave a confession which was recorded on a cassette tape, like this. Keep in mind, this is 1997, so the technology was still cassette tapes. It wasn't digital. And he confessed that he did it. That he knew her, that, I don't remember, he had lots of details in his confession, as Steve suggested. The details, I'm sure, had been fed to him. We know, had to have been fed to him by Ford. But that he acted alone, that he raped her and then killed her afterwards. And that was consistent with the police's assumptions going into the investigation. They had a confession from Dan Williams, they had their man, crime solved, end of story. So just to make sure, of course, they get a biological sample from Dan and they send it out for DNA testing. And back in those days, it took a while for results to come back from DNA testing. And it was actually about 4 or 5 months later, I believe, that the results came back. He was excluded. And there had been lots of DNA left at the scene. There was semen in Michelle's body. There was semen on bed covers, on a blanket, I think, that she was found under. And there was also blood, I think. I think she had blood under her fingernails. All of this got tested against Dan Williams' DNA. All of it excluded it. Now, go back to Ford. Rather than suspect that he might have the wrong guy and he might have gotten yet another false confession, as Steve pointed out, he had previously gotten a false confession from 3 teenagers and in fact had been disciplined for it. This becomes relevant, as you'll see, more relevant even to the case later on. Ford hauls Dan Williams back in and says, "You lied to us. You had an accomplice, didn't you?" And eventually, after that kind of a browbeating interrogation, Dan Williams gave him the name of Joe Dick, another young sailor. Ford brings Joe Dick in. Another multiple hours of interrogation, none of which was recorded. The pattern repeats itself. Joe eventually confesses that, yeah, he and Dan Williams did this together. Just the 2 of them. But they got in because Dan knew Michelle, and again, lots of details in his confession, which was recorded on a cassette tape. He was interrogated in January of '98. So Dan was interrogated in July of '97. Joe Dick was interrogated in January of '98. So there's, what, about a 6-month time span there. They send biological evidence from Joe out to be tested, and sure enough, 2 months later, it comes back. He's excluded. Now, at this point, I think Ford realized, he had to have realized that in Joe Dick, he was a very vulnerable suspect, very vulnerable witness. Joe is, it's fair to say he's mentally challenged. He's not retarded. I mean, he did get into the Navy, but he didn't score very high on the battery of tests and so on and so forth. So he brings Joe back in, and of course does the same thing with Joe that he had done with Dan, and he says, you know, you lied to him. There had to be someone else involved because Dan Williams' DNA is not there. You said both of you raped her. Dan Williams' DNA is not there. Your DNA is not there. Who else was involved? Well, it's at this point that Eric comes into the story. I don't remember the details of how Joe came up. Somebody named Eric. He didn't know Eric's last name. I don't really know, or I can't remember how Joe knew even about Eric. They actually went through a yearbook type book, picture book of sailors on Eric's ship. And Joe went through and pointed out the picture of someone named Eric who happened to be Eric Wilson. Eric gets brought in for interrogation on April 8th, 1998. 9 months to the day, as it turns out, that Michelle's body was discovered. A multiple hour interrogation, probably longer than 10 hours. I was talking about it with Eric this morning at breakfast, and he thinks the interrogation started sometime shortly after 8 in the morning, and he remembers going outside to smoke a cigarette at dusk. This is in April, so dusk would have been sometime after 6 in the evening, to smoke a cigarette, and it was before he confessed. So it was while the interrogation was still going on. He eventually confessed. This is the actual cassette tape of Eric's confession, and it's recorded on that tape. And he confessed that, yeah, he did it, and there were 3 of them. And he did not, fortunately for Eric, he did not confess to being present when she was killed. And we're going to play, I don't know, can we do this? We're going to play, we've got about 3 excerpts from his confession. I thought it would be helpful for you all to listen to a couple of excerpts. The whole confession is about 12 or 13 minutes long. It's not that long. And it's basically the 2 voices you'll hear are Ford's voice and Eric's voice. And the thing that's striking about this, as is true of all of these false confessions, is the details. I mean, keep in mind, he's talking about something he knows nothing about, other than what he's been told and shown during the interrogation, the unrecorded interrogation session.
I don't know if I have these in the right order.
Well, just whatever. All right, that's 4. Tell me in your own words what you know about this offense. Start at the beginning and go all the way through to the end. Go ahead.
Oh, is that it? Oh, okay, sorry.
Sarah. So were you able to hear that? Dan finished raping her and then I went next, and so then I started raping her, and then when I was done, Joe got ready. And then the tape continues, and as Eric is telling this, giving this confession, things were starting to get rough, but he left. He says he was disgusted with what he had done and he left, and he did not return. So in his telling of the story, he was not present when she got killed. The pattern repeated itself. 2 months later, the DNA, Eric gave a sample, the DNA test came back. They were getting better with doing these tests. It wasn't 5 months, it was 2 months now. Came back, he was excluded. So they didn't bring Eric back in. But by this time, pretty soon after the confession, Eric realized that he had made a huge mistake. And he ended up, this is not part of the story I'm going to tell this morning, but I'll just mention that he ended up, through his family, getting a fantastic lawyer named Greg McCormick, who is basically a solo practitioner in the Norfolk, Virginia Beach area, does a great job, and he did a great job on Eric's case, given what he had to deal with. And I'll come back and tell you about that in a second. So they brought Joe Dick back in. Remember, Ford had his man when he had Joe. So he brings Joe back in and said, all right, Joe, you lied again. You lied again. There had to be more than 3 of you. Who else was involved in this? Well, they eventually get to a guy named Derek Tice, who by then was out of the service. He was down in Florida. He had been discharged from the service. They haul him back up. They interrogate him. He confesses. He eventually produces 3 more names, Rick Pauley, Jeff Ferris, and John Dancer, who get added into the mix. So now it's 7 of them, according to Derek's story, who participate in this gang rape and murder of this young woman. And that's Derek's recorded confession. This is, by the time they got his confession, probably was late '98. And then, in early 1999, a man named Omar Ballard, who was in prison for another assault, an assault of another woman, wrote a letter to a friend of his on the outside bragging that he was the one who had killed Michelle Bosco. I mean, this is the Matias Rios guy, just like in the Central Park 5 case. The police went out, they interviewed him, they took DNA samples from him. It was a match. It was a complete match. He said to the police that he acted alone. These other 4 guys had nothing to do with it. They're the stupid ones who opened their mouths, he said at one point in all of these proceedings. So, what do the police do? They morph from a 7-person gang rape to an 8-person gang rape and murder. Omar Ballard being the 8th. And that was their theory that they proceeded under, at least when it came time to try Derek Tice. Joe, Dick, and Dan Williams pled guilty. As these facts came out, particularly the DNA exclusions and Omar Ballard, we found out about Omar Ballard and his confession and the fact that his DNA was a match. They tried to withdraw their pleas. The judges would not allow them to withdraw their pleas. They wanted to withdraw their pleas and go to trial. The judge said no. Eric had good counsel, as I said before, a guy named Greg McCormick. Eric went to trial, and he went to trial in June of 1999. So this was almost 2 years after the murder. And the state sought a murder conviction as well as rape against Eric. Because they had, besides Eric's confession, Eric did not confess to being involved in the murder, but they had his confession to the rape, and they had Joe Dick's testimony that Eric was involved in the murder. So they had evidence with which to argue to the jury that Eric was also guilty of murder. The jury convicted Eric only of the rape, not the murder, and recommended a sentence of 8.5 years, which I think in hindsight, certainly the experienced lawyers in the room will know, given such a horrible crime, that was obviously a compromised verdict. But the jury, and they were told about Omar Ballard, they were told, now Omar Ballard did not testify. He was called to the stand, he refused to testify on the ground of the Fifth Amendment, because by this time, Ford and the others involved in prosecuting these guys told Ballard that if he wanted to avoid the death penalty, he could not come in and say that he acted alone. Could not come in and say he acted alone. But by the way, speaking of death penalty, one of the things that happened during Eric's interrogation was he was threatened with a death penalty if he didn't confess. So Ballard doesn't testify. The jury, faced with the confession of Eric in his own words, which they listened to all 13 minutes of it, and Joe Dick's testimony, the confession corrupted the evidence to such an extent that they returned a guilty verdict. And then Derek Tice went to trial twice, and he was convicted both times of rape and murder and sentenced to life in prison both times. So that's where I'll leave it. I got involved in the case in 2005. By then, between 2000 and 2005, several pro bono lawyers took on these cases and commissioned a complete reinvestigation of them, and then ended up putting together a clemency petition to the Virginia governors. But that's the story. That's the story of their exoneration, which I think we'll talk about later. But Eric served his full sentence. He got full maximum credit for good time. So he served a little more than 7 years and got out. And as Steve alluded to earlier, he still lives today as a convicted sex offender. He and his wife, Misty, who is also here today, they live in Texas, southwest Texas, south of San Antonio, with their 2 boys. And life goes on. And he's doing remarkably well, given what happened to him. So, thanks.
Brandon goes next.
Oh, Brandon's going to go. Excuse me. All right, sorry.
I have some PowerPoint on the here we go. And you have a
Can you tell us why the investigator is now in jail?
Yeah, I will. That's yet another bizarre chapter in this story that nobody really knew about. In February of 2010, the clemency petitions were filed towards the end of Mark Warner's term as governor. There was not enough time for him to have the cases investigated, so he turns it over to Governor Tim Kaine. And the Kaine administration investigated it thoroughly. There was a lot of pressure from within the administration to uphold the convictions and not to grant any relief. The parole board in Virginia When a governor gets a clemency petition, the governor does not have the staff to investigate the facts of a case. So they rely on the parole board to conduct the investigation. And at the time, the chair of the parole board was a former U.S. attorney for the Eastern District of Virginia named Helen Fahey, and she strongly advocated in favor of the convictions, as did Ford, who came to Richmond, to the governor's mansion, to argue in favor of the conviction, and the prosecutor, D.J. Hansen, who was an assistant Commonwealth's attorney, but he was sort of the lead prosecutor on the case. And they urged the governor not to grant any relief at all. And eventually, in August of 2009, Governor Kane granted partial pardons to Joe and Dan and to Derek, because they were still in prison serving life sentences. He granted no relief to Eric because Eric was out. He basically commuted their sentences to time served. They were released on probation. They're going to be on probation for 25 years. And of course, they all had to live as convicted sex offenders. In February of 2010, so this was 6 months, 5-6 months after Governor Kane granted his relief, the feds unsealed an indictment of Ford for running an extortion scheme out of the Norfolk City Police Department. And the gist of this scheme was, in return for under-the-table payments from people charged with drug crimes or convicted of drug crimes, he would come in and testify that he's the chief homicide detective for the city of Norfolk. I'm conducting an investigation of a very significant homicide case. This particular person is a key witness for us in this investigation. He's cooperating completely with the police. Go easy on him in setting his bail or in determining his sentence. And it turned out none of that was true, and this had been going on for years, and it predated his involvement in the Norfolk Four case. So at the time he got involved in the Norfolk Four case and couldn't afford to admit, remember I said he couldn't afford to admit that he had been involved in another false confession? If he had admitted that he had gotten any of these guys to falsely confess, he probably would have been dismissed from the force. And that would have been the end of his goose that was laying the golden eggs for him. He went to trial, federal court, Norfolk, convicted. He's serving a 12.5-year, 150-month sentence right now in federal prison. And Governor Kane knew none of that at the time he acted on the clemency petitions.
Thank you.
Well, this is an amazing event. It's an honor to be here, particularly to see Raymond after so many years and to meet Eric Wilson. I'm going to talk to you a little bit about the problem of confession contamination, which Steve described very well at the end of his talk. I want to unpack it a little bit farther and also explain to you how one might try to litigate confession contamination, but also some of the challenges of litigating it, particularly in the post-conviction context. So, this is Earl Washington's confession. You're going to hear quite a bit more about this case later in the day. This is the whole confession. I don't recommend using this as a legal tool, but I thought this way I could fit the whole confession on one slide. It's a word cloud of the words in his confession, one of the best known false confessions in the country, and a case that had enormous repercussions here in Virginia. You can see, just by seeing how large the words yes and sir were, that he was unfailingly and unflaggingly polite during the written down responses that came towards the end of the interrogation with him. And as you'll hear, he's an extremely compliant person, and in fact he willingly confessed to a number of crimes that they knew he didn't commit, because the victim said there was no way he was the person. But in this particular case in Culpeper, the victim had been murdered, and so she couldn't say that he was innocent. But the officers who were interrogating him absolutely knew that he could give false confessions. And in fact, they had recorded the interrogations of other people, but they decided that they had better not record this one. What you can also see is that there are lots of little details floating around the yes sir aspects of the case. The murder did happen in an apartment, and so many questions were asked about the apartment. There are details concerning a knife, a bedroom, a stabbing, a shirt. All those details were important in the statement that ultimately sealed his fate, although it's certainly a red flag to trained detectives if someone who you are questioning can't answer questions except by saying yes sir a lot. Right, that suggests that they can agree with what you say, but what you want is for them to be able to tell you something on their own about the crime. So, I've researched these cases. Earl Washington's case, by the way, is a case where ultimately DNA testing secured his exoneration. There are many, many more false confessions in cases in which DNA testing can't be done. As Steve said, many of the false confessions that we know of and that have resulted in exonerations are in murder cases and homicides. It's particularly important to secure a confession in a case involving a homicide where there may be no witnesses to what happened. The main witness may be the victim who was murdered. And obviously these are high-profile cases where police want to invest everything they can in closing the case. That said, we will hear more later today about juvenile cases. Right? You don't necessarily need to interrogate juveniles for 15 to 30 hours like in the Central Park case to get them to confess. Many juvenile confessions occur after a half hour of interrogation. And far less is known about how many juvenile confessions are false, particularly due to the informality and lack of documentation in juvenile courts. The false confessions that we know of are just the tip of some kind of iceberg. We do not know very much at all about the frequency of false confessions, and there's a reason why. It's because of the difficulty in ever uncovering whether a confession could be false because of the reliance that our system places on confession evidence. So I talk about a lot of the cases that I will tell you about today in a law review article in the book, and maybe more useful, a lot of the information in these cases, including transcripts and confession statements, I have available online on a not very fancy but hopefully useful resource page. Like Steve mentioned, although it's just 16% of the first 250 DNA exonerations that involve false confessions, the numbers have gone up, mostly because of the city of Chicago. Many new exonerations in confession cases in Chicago. People talk about, for example, eyewitness identifications are the leading cause of wrongful convictions. All of this is misleading because the DNA cases tend to, by their nature, be cases involving sexual assaults. In the rape cases, unless it's a case like the Central Park case where there's no victim who can identify the assailants, typically in the rape cases there tends to be an eyewitness, maybe some forensics accompanying the eyewitness testimony. It's in the murder cases where you tend to see the confessions. But unless there's a sexual assault in the murder case, there may not be any DNA testing that can be done. So, back to Earl's case. Again, I don't want to talk too much about this case, but what was really important in his confession wasn't the many, many minutes and pages of discussion with yes sirs. And in fact, he said yes sir and volunteered lots of details that were wrong. When he was asked in an open-ended way, what was the race of the victim, he would get all that wrong. He said black. And there's a wonderful Frontline documentary about his case where he said, I don't know, I just figured she was black. They drove him all around town so he could show them where the apartment was, and he took them to all sorts of places in Culpeper. So here they're showing him a shirt from the crime scene. And this was non-public information. The shirt had in fact been found some months afterwards when the victim's family was cleaning out the apartment. The press had never discussed this shirt, but they're holding it in front of him. And so, is that the one you left in the apartment? Yes, sir. That's not particularly probative of, that's not inside information. How do you know it's yours? That's the shirt I wore. That's not a terrible guess. What makes it stand out? A patch had been removed. Well, they're holding it in front of him. Fine. Whoa, here we go. Why did you leave the shirt in the apartment? And this brief passage was what was important in the case. This passage sealed the entire case. It had blood on it, and I didn't want to wear it back out. Now that was something that one could not see by looking at the shirt, unless one was a trained crime scene technician maybe. There were a few kind of pinprick type holes where they had cut out some small dots of blood for forensic testing. And in fact, the blood testing excluded him at the time of trial, but the jury didn't hear it. And a lab report was actually altered, and the defense lawyer should have wondered when the lab report said amended lab report. Well, what was the first lab report? But especially someone of limited intelligence like him, would he be expected to know that these pinprick holes were the places where blood had been, but it wasn't there now? Right, that was a detail that was extremely powerful, and laid it on top of the dresser drawer in the bedroom. I mean, lots of bedrooms have dresser drawers still. That was a telling detail about where the shirt was, and it was in fact found in this dresser drawer months later. No one knew about it. So those were the details that were the centerpiece of the prosecution case. The prosecutor at trial emphasized those details in his closing arguments. How does somebody make all that up unless they were actually there and they actually did it? That was the core of the prosecution's argument in the case. Because the jury saw Earl Washington, they could see that he was slow. He absolutely recanted and said, I don't remember where I was that particular day. That day didn't stand out for any reason. I was probably doing farm work, but I didn't have anything to do with this. They focused on the details concerning the shirt. During the direct appeal, the Virginia Supreme Court emphasized the shirt in discussions of why the confession was voluntary, why he had the capacity to waive Miranda warnings, and all sorts of other evidentiary objections that were raised on appeal. Federal habeas. The strength of the prosecutor's case lies beyond the mere voluntariness of the confessions. The numerous details of the crime were emphasized by the Fourth Circuit in an opinion by Judge J. Harvey Wilkinson, a Charlottesville native. The jury could afford his confession substantial probative weight. And even after the DNA tests were done in 1993-94, then Governor Douglas Wilder, L. Douglas Wilder, in language very similar to Kane's language, denying full clemency to the Norfolk Four, only granted partial clemency, took Earl Washington off death row, but he was at that point going to serve life in prison, saying, look, come on, these details. The court's focused on the details, the governor focused on the details, every step of the way. That brief Q&A, that the answers to 2 questions were what turned this case into a death penalty case. From a case of someone who had been falsely confessing to a bunch of crimes, falsely confessed to one more. What is fascinating, and what only came to light in the civil case, the civil rights case that was litigated in Charlottesville shortly after I moved to Virginia, it turned out that one of the detectives, when asked at the time of the DNA testing in 93-94, when they were doing a review of the case, and maybe realized, oh wait a minute, they're doing DNA now, something is going to come to light in this case, the detective admitted candidly that actually maybe we were the ones who mentioned that stuff about the shirt first. Maybe the written statement that we produced and that we described to the Commonwealth's attorney in the case, maybe that wasn't so accurate. Now, is that the detail that you can just sort of casually, oh, wait a minute, maybe it did happen the other way? Right, this was the core of the case. To get that detail wrong, it's extremely troubling. And the claim in the civil rights case was that this confession was in fact fabricated. And a theory under Napoo versus Illinois, not just a Brady violation, but that the confession was itself fabricated evidence, which is a theory that probably should be litigated in more of these cases. Now, we will hear more about police training from Jim Trainum, and it's fantastic that we have him with us here today. The Bible of Police Interrogations is clear on this point. And in fact, Joseph Buckley, his name is third there, he's the head of the Reed Institute now, I think, came and testified in Earl Washington's trial, saying what they did in this case in Culpeper is absolutely contrary to our training. What should be sought are facts that would only be known by the guilty person, so absolutely detectives focus on this inside information. They know that it's not just enough to get someone to say, I did it, because innocent people can say, I did it. Lots of people came forward and said, I did it in response to the Lindbergh baby case. We know that for all sorts of reasons, people, even who are not coerced at all, may volunteer their guilt even though they're innocent. Police are trained to ask open questions, though, about those details. What did you do next? Non-leading questions. And If the person can only say, I did it, then you should be really worried about that confession statement. So, not only do you do that, but you don't reveal those details to the press. You want to know that this person learned of this inside information about the shirt or whatever it was because they were there at the scene, and you don't want them having learned it from the paper, from the newspaper, from media accounts, from police having talked to witnesses about it. Maybe they're talking amongst themselves. They recommend even keeping the evidentiary record in the police station so that these facts are blacked out. They're marked as confidential in the file. And that way you can confidently go to court and say, we absolutely kept a lid on this fact about the shirt. We told no media, we told no witnesses, and yet this person came to us and confessed and told us about the shirt. In this Ron Williamson trial, that's exactly what the police said that they had done. We now know that that must not have been true. You don't give up your evidence, the officer said. That's the case that John Grisham wrote his book, The Innocent Man, about. Here's an example of just another one of these cases with a litany of details. The color of the couch, what the house was like. This was a pattern across, almost without exception, the false confessions that I studied. And I'm now updating this to include 19 more recent DNA exonerations with false confessions. I have no doubt the pattern will hold. In fact, the only two cases in which there were not these details were cases where the detectives tried to feed facts, but they were unsuccessful. Including the wonderful one is the Freddie Peacock case in New York, where the detectives describe how we just kept trying to tell him stuff about this woman. You remember the woman with the red hair who lived in your building? We're her, right? But he was so severely mentally ill that he just sort of couldn't take the hints and couldn't say things to them that made any sense. He could only say, I did it, but he didn't really know what he did, and was having trouble taking cues from the police. And finally they gave up in frustration. And they got her to identify him from a lineup, so they didn't need a confession. Now, none of these confessions were recorded in their entirety. They were all recorded towards the end, although in some cases the exonerees have described how police turn the tape on and off to interrupt things, to show them pictures and feed information. Quite a few of these individuals were vulnerable, including juveniles and folks that were mentally limited, but many were not. Quite a few of these individuals also pleaded guilty. And they've said afterwards that their lawyers told them, you confessed. Your case is sunk. Many of them, after the suppression hearing, once it was clear that the confession was going to come in court, their lawyers advised them, just plead guilty. Take the deal. And we have no idea how many people there are out there who took the deal, got out after a few years, and never tried to later get DNA testing. For understandable reasons, perhaps. So few cases can be tested using DNA. In so few cases is the evidence preserved so that it can be tested using DNA. I've talked about contamination already. These are examples where the police had to work with the witness, sometimes aggressively, to make sure that the details came out right. This individual in one of the multi-confession Chicago cases, he didn't know what concrete was, and he kept saying brick. It happened at trial too. It was really hard for them to successfully contaminate this. So again, like a chunk of cement. They just couldn't get that cement thing to stick. In some of these, even just partially taped interrogations, you can hear the detectives feeding facts on the tape. And that's obviously something extremely significant if there is a recorded interrogation and you're reviewing the records in the case. Many of us who get sent recordings of interrogations by lawyers who are wondering what to look for, that's certainly a red flag. If the person is not answering questions with details on their own, if they're only saying yes sir, but also if when they do offer details, the details are wrong and then the detectives have to correct them, or even show them pictures like in this case and say, you remember this, you remember by the water fountain? And he was also mentally ill. He really was having trouble following the leads that the detectives were giving him. But again, sometimes contamination is quite clear from the portion that's recorded. And again, examples of investigators saying at trial, we absolutely did not contaminate this evidence. That is a problem. If there's no recording and there's no record of who said what, it is common in these cases for law enforcement to come in there and say, we never told them any of these details they told us. If there's no recording and you can't document something like this, the feeding of facts right there on the record. If there is no record, it's very, very difficult to litigate these cases. All of these people waived their Miranda rights in these DNA cases I studied. Almost all of them, without exception. There was one exception, but they did bring another challenge. Challenged their confessions pre-trial. There were suppression hearings. These cases were almost all unsuccessful, except in one Chicago case where there was evidence of police torture. And you wonder in retrospect, how in the world did judges find these confessions voluntary? All but 4 were interrogated for more than 3 hours. The Reed guidebook suggests you never should need to interrogate someone for more than 3 hours, except it certainly happens frequently. Many of these people were suggestible. A number of these people described seeing this in a dream or a vision. Many were told they failed polygraph tests. Several described threats or physical force. Many of them described the false evidence ploy that Richard Santana talked about last night. You know, we have your fingerprints on the victim's shorts. We have your DNA at the scene. Police can use all sorts of deception, and that happened in these cases. But courts don't review the reliability of these statements. They're just asking this very deferential, totality-based question whether the person's will was overborne. So the Supreme Court has said that reliability is basically something for state law, for state 403 type reliability rules. It is not of constitutional importance, and it is not the question you ask when you're asking whether under the Fifth Amendment and the Due Process Clause a confession statement shall be excluded or not. You're asking whether the person's will was overborne when they said, "I did it." You are not focusing on all those other details that may be contaminated or not. Those details, though, the story that emerges, is what will be crucial in front of the jury, not whether just the bare "I did it" was the product of coercion. State law rules don't really add to this. They sometimes require corroboration, but just in the sense that, yes, we found a victim's body, therefore we think there was a murder, which really was an issue, and maybe sometimes difficult back hundreds of years ago when victims' bodies may be taken away by wild animals and the like, and there may be no body, but not hard to satisfy that requirement in most cases. I've talked about deception, and I should wind down. The subject of expert testimony in false confession cases is a very important one, and we should talk about it more today. Very few of these exonerees were able to get experts. There is incredibly conflicted case law, which varies in ways that are totally inconsistent state by state. Virginia, for example, is a state in which the Virginia Supreme Court has said that trial judges may, they certainly don't have to, but they may permit experts to come in and testify about the general phenomena of false confessions, because that isn't something that is intuitive to jurors. Most people don't realize that A, false confessions can happen, and B, that false confessions can seem so reliable due to these details, due to the problem of contamination. Those are important subjects to educate jurors on, because they're such counterintuitive subjects for most people. But that said, in Virginia, courts are not so tolerant of actually having someone do a clinical evaluation of the person to find out whether this person was suggestible. They've said, no, the question is just voluntariness and capacity to be tried at all. So that kind of clinical evaluation is not so smiled upon. In other states, it's the reverse. They'll allow the clinical evaluation, but they won't allow the general testimony on false confession research. And opinions are all over the map. Plus, there's the question of, so the trial judge may have discretion, but are they going to provide funding for this expert? And how are they going to exercise that discretion in a particular case? Although there's an amazing case, the Jerry Frank Townsend case, where he had a battery of experts, an amazing set of experts, 7 different experts, all talking about how mentally ill he was and how flawed the confession was. And actually the prosecutor was the one who was outgunned in that case. Who knows why? The prosecutor had this expert who barely sort of had a medical degree of some kind. It was unclear how this expert was even qualified and seemed overwhelmed by all the evidence on the other side. This sort of hapless expert just kind of said, I don't know, seems guilty to me. And the judge said, well, it would be good if all confessions were perfect. But basically the judge said, because of he had so much knowledge of street parlance and he had so much knowledge of the details of this crime that I just don't buy all this expert testimony. I think this is a great confession. So these details are so powerful that even having experts, even having DNA tests on your side may not be enough. Again, prosecutors emphasizing these details. One other problem for a defense is that there may be very little investigation of the case that could give you other leads precisely because of the confession. In many of these cases, law enforcement described at the time or afterwards how their work on the case ended once the confession occurred. Now, for practitioners figuring out what to do in this case, one can look for evidence of feeding or contamination in a recorded interrogation. You can look for someone who's just saying yes, sir, and can't provide detailed responses. Obviously, there are other red flags in terms of whether this person is suggestible in the first place, the length of the interrogation. One other thing that experts look at is this question of lack of fit. When the person is given an opportunity to volunteer answers, if they get the details all wrong, that should be a red flag. Now, prosecutors often say, well, this person was being tricky and purposely giving incorrect information so that they could beat the rap and sort of fool the system. That said, if someone is given a chance and their will has been somewhat broken and they are telling the interrogators what they want to hear, but they just can't get it right because they don't know the details, like Earl Washington, who said the victim was black when she was white, he said she was stabbed a few times when she was stabbed 37 times, that is a significant red flag. There are also fascinating cases where police feed false facts unintentionally. If you have interrogators who don't know the crime scene very well, and so they say, so, you busted open the screen door, like in the Eddie Lowry case in Oklahoma, in Kansas. Well, it turns out the crime scene guy said, actually, the screen door wasn't busted open, it was cut with a knife, or the reverse, I can't remember which. So they went back and had said, we need to take a new statement from him. Remember what you said about busting open the screen door? You actually cut it with a knife. Oh yeah, I cut it with a knife. Clear indication that there is aggressive contamination going on. So, like Steve mentioned, many of these cases involve people who were excluded by DNA at the time of trial. Here's a judge who maybe should know better than jurors, maybe clearly not. Says, I don't know about this DNA, the scientific evidence, I just think this confession is so detailed. Post-conviction, court after court after court, not just in Earl Washington's case, across the board in these cases that I've studied, emphasize the details in these confessions in the course of saying that there's overwhelming evidence of guilt and therefore whatever errors that there were harmless ones. And so this evidence of guilt can also corrupt the harmless error analysis and other inquiries that courts engage in post-conviction when they're deciding whether errors deserve a vacatur of a conviction. In general, very few of these exonerees had any luck challenging their confession evidence. There was somewhat more luck that they had challenging eyewitness evidence and other forms of evidence. Here's the very first DNA exoneration in Virginia and one of the first two in the country. Aggressive feeding of facts. Because David Vasquez, unfortunately, wasn't familiar with Venetian blinds. And, some of us are more interested in the subject of window treatments than others. And he clearly wasn't interested in interior decorating. And the victim was strangled with Venetian blind cords. And this is taped. He says, what did I use? Ropes? That's a pretty good guess if someone was hanged, right? And they said, no, what did you use? He's like, a belt? I actually am not sure whether you can hang someone with a belt. I would think it would have to be a long belt. Bad guess. They said, okay, something in the sunroom. Clothesline, that's a really good guess. Then finally he has to say, think about the Venetian blinds. Remember cutting? And he's like, is that the same as rope? He has no idea what Venetian blinds are. And those Venetian blind cords, I think they are kind of dangerous. Maybe it is good that you don't see them so much these days. And now he's still saying, she told me to grab the knife and stab her. He has this kind of suicide scenario, which has presumably been fed to him. My fingerprints are on it. It sounds like they were telling him his fingerprints were on it. Finally, you hung her. Okay, so I hung her. And this is the case where once the judge said, oh yeah, this all seems voluntary, this is coming in, his lawyer counseled him, take the plea, he took the plea. Finally, I'm winding, this is my last slide and I'm done. Just to show you how the patterns in these cases are consistent, here's another word art image from a Chicago false confession by Ronald Jones. This is his confession statement. And you see yet another big yes, sir, surrounded by lots of little details. So I'll stop there.
So we thought that a good way to get Eric and Raymond to talk about their case would be to ask some questions of them. And you're free to answer these questions any way you want. But obviously one of the big issues in these cases, when I've had clients who falsely confessed and I've tried to debrief them, it's a difficult thing to explain to people. What it was like in that interrogation room, and it takes a lot of work on the part of attorneys to get that information out of your clients. And it's not because they're not telling the truth, it's because there's so much coming at them. It's so dynamic that it's hard to put into words. And they often say, you just had to be there. But I'm going to ask both of you, if you don't mind, to sort of take us back for a minute, if you will, into the interrogation room and sort of share with us what it was like.
You know, since this film came out, we've been all over the country, right? And we did a lot of Q&As, film festivals, and that question came up a lot. You know, why did somebody confess to something that they did not do? And so, you know, we got to look at it, and you got to say, wait a minute, why do they do that? You know, and for me, I had to say, wait a minute, you got to look at the scene first, right? You got to weigh it. We were 14, 15, and Corey was 16, but he was mentally challenged. And so we never had any issues with the law, right? Never been arrested, never had any runs with police. Didn't know what Miranda was. And also our families didn't either. My father, you know, he had a 10th grade education. He didn't know, you know, he didn't know his rights. And also he was in fear. So when you look at that, and then you look at the opposition, these are detectives. This was the elite of the police force, the Homicide North Detective Squad. Been on the force over 20-something years. You know, numerous convictions under their belt. And so this for them was just business as usual, you know. And so you go into this room, interrogation room. It's cold, right? You don't know what's gonna happen. You don't know what's going on. You just know you're there. It's the unexpected. And so they start off nice. Well, Raymond, just tell us what happened. So you start telling them what happened, you tell them the story. Well, what about this? What about that? What about this? What about that? And so that goes on for a process, right? You give them what you perceive to be the facts, but I think one thing that should have helped us was that they didn't have all the facts. You know, in our statement, we don't talk about how Patricia Miley was bound and gagged because they didn't bring that in. You know, they didn't know what she had on because her shirt had so much blood that you didn't know if it was red or it was originally white. So we got those facts wrong. The only thing they knew was that she was found in the ravine over by the transverse and that she was gonna most likely die. And so it starts off slow and it starts off, you know, polite. Ray, tell us what happened. Who were you with? What did you do? What did you see? And as time goes on, it becomes more aggressive. Now, my grandmother was there, right? And so she spoke very little English. She can talk curse words in English, she can give you that. But she couldn't give you a full conversation. And they understood that. They knew that. So what they had to do was get her out the room. So you would hear a knock at the door. The officer would come in and he spoke Spanish to my grandmother. And he said, "Can I speak to you in the hallway for a minute?" And she would get up and she would walk out. Why would she walk out? Why? Because these guys were considered authority figures, right? So she didn't question them. And so she's outside and she's in the hallway, and the whole time he's telling her, we don't think he's telling us everything. We just want to get to the bottom. This is the reason why it's taking so long. And she's just nodding her head. Meanwhile, I'm in the room, and this is when they start to work on me. So the first incident, I'm sitting there. I was 14 at the time, must have weighed about 90 pounds, and I was scared to death. This tower officer comes in, and he's talking to the fellow officers, and he looks at me and he says, "Well, this is the scumbag." And he said, yeah, but he's not giving us all the information. So he gives me this piercing look, right? And he says, what are you looking at? I'm scared. I'm ready to just, crap in my pants right there. And so he makes this move like he's gonna lunge at me. And so that was the first sign. I was like, well, I'm in trouble. I don't know what's going on. But right then and there, as I knock at the door, detective looks in, my grandmother walks in, back to business as usual. So, Ray, tell us what happened. Who were you with? What happened? What did you see? We're going through the story again. Now, this is going on for numerous hours. I don't know, but this is the breakdown process. This is a scene out of Law and Order. And so it goes on a couple more times where I'm, my grandmother leaves the room and I'm afraid. But the last time was like the ultimate. This was my breaking point. And so Detective Arroyo, who was one of the lead investigators in my case, he's questioning me. And he bangs on the table and he starts yelling at me, he starts cursing. This is it, I'm tired of this, you're not giving me what I want. And he goes to reach for me. At this point, I'm like, oh, this is it. I'm not gonna make it out this precinct. I'm gonna die right here. But just at that moment, another detective comes in and stops him. This guy was named Detective Hardigan. He stops him, pushes him back. What are you doing? Everybody get out the room. Kicks everybody out of the room. I'm sitting there going, whew, this guy just saved my life. Everybody leaves, he comes back, sits down, and this is where it starts. Raymond, you're a good kid. I know you didn't do this. But these guys in other precincts, and they're saying you did it. I need you to help me. You want to go home, right? Of course I do. Okay, I need you to help me. You gotta tell me what happened. But I don't know what happened to this woman. Pulls out this picture of Kevin Richardson, puts it on the table. Do you know him? No, I don't. This is Kevin. See that scratch of his eye? That came from the woman. He's going to jail. But I don't want you to go to jail. You gotta help me. So right then and there, it's formulating. How do I get out? All right, you know what? Kevin did it. Kevin did it? Yeah. What did you see Kevin do? Struggling with the woman. And this is how the story starts to formulate. But I don't have the facts. I don't know anything. I didn't even know who Kevin was. So he had to feed that stuff to me. What did Antron do? What did Steve Lopez do? The reason why Corey and Yusuf aren't in my statement is because he didn't give me their names. If not, they would have been in there because they weren't arrested till the next day. And so, he even fed me the facts of the weapon use. I told you that last night. He said, she was found in the ravine. She lost a lot of blood. Something had to be used. A brick, a knife, or a pipe. He gave me options. Which one you want to use, Ray? And I used the brick. Sure enough, a brick was produced at trial. And so, and that's how it went on. That's how the interrogation went on. After I was at a point of being broken down, and I just wanted to get out of there, and I gave him a story, he said, all right, that was good, but you're gonna have to do something else for me. At this point, I'm thinking I'm a witness. Yeah, what you need me to do? As long as I get to go home. You're gonna go to another precinct, and you're gonna tell another detective the same story you told me. Sure. If it's gonna get me to go home, I'll do it. This is why my statement went from 2.5 pages to 5. Because the other detectives wanted to bring more stuff out of me. And a lot of points that were brought up here today is in my statement. The wording. At approximately 1400 hours, me and 30 of my friends went into Central Park and we traveled southbound. And if you don't believe me, look it up. Get the statement and read it. It says it. We traveled westbound, eastbound. What is that? I don't even know what that is. I never even been to Central Park. I can't even tell you where I was at. The reservoir. I didn't know about the reservoir. I just knew it was a lake with a fence. That's the reservoir. But this is the stuff that was fed to us. And then it's even produced in trial. This is the brick that was used in trial, which later on was tested, and there was no blood on it. Our clothes had hair fibers that they said, was possible. When they went to the crime lab and they came back, They found out that our clothes were laid down in the precinct. It was contaminated evidence. But this is what they got away with for all this time, for all these years. You know, and that's how, for me, the forced confession came about. Of not knowing, being inexperienced, being vulnerable, you know, and also my family going through the same thing as me. Not knowing, never went through this process. But it happens all the time. You know, and I don't want to give too much because then I'll be telling his story.
Thank you. Yes, sir.
Howdy. You know, it's funny how the stories are strikingly similar. It's like you can read it straight out of a book. I like to give a little bit about myself first, just so that you understand where I'm coming from. Because you wouldn't think someone like me would give a false confession. I'm not a vulnerable suspect, like they put it. I grew up in a small ranching town in South Texas. When I say small, I mean my graduating class was about 30. We were taught to respect the police, respect authority. You do as they say. I'm an Eagle Scout. I went through that whole deal too. I joined the military because my family didn't have enough money to send both of me and my brother to school. I figured my brother had a better chance at it than I did. So I joined the service and let him get his schooling. I had just come back from the war. Hadn't even had a chance to go on leave when I was actually on duty. I just had the 4 to 8 watch that morning. For those of you who've been in the military, you know the 4 to 8 watch lasts from 3:45 in the morning to 7:45 in the morning. I just come off of it. I had just put on my coveralls to start work the next day when a detective came from the NCIS and took me to the police station. He said he wanted me to answer a few questions about Dan Williams. Dan Williams I knew for a short amount of time. I was actually friends with his wife, and that's how I met him. And that's also how I met Joe Dick, who happened to be their roommate. In the service, you'll find a lot of couples have single roommates to help pay the bills, because honestly, none of us make more than minimum wage. I remember talking a lot about baseball on the way up to the precinct. I love baseball. I got into the room and I figured, you know what, I'm just going to say what I know about Dan and I'm going to go home. I got work to do. I got in there and I told him, I said, look, Dan Williams didn't do this. I know because his wife told me he didn't do it. She was dead at that point. She had died of ovarian cancer while I was overseas. So she couldn't give those statements herself. She had told me that he was with her at the time it had happened, and I believed her, and therefore that's what I told the police. At this point, I knew nothing of Joseph Dick. I didn't even know he'd been arrested. Remember, this is what, almost 2 years, year and a half, 2 years later. He said, okay, well, just tell us about Dan. So I started talking about Dan. I said, look, I told you what I've told you previously already. Then they said, do you know a Joseph Dick? And I kind of cocked my head a little bit. I was like, thanks, Phil. And that was his name. Like I said, I only met him like once or twice, so I don't really remember names too well. They showed me his picture. It's like, oh yes, that's Dan's roommate. We've gone out a couple times. Felt sorry for the guy. He's a little slow. Very socially awkward individual. They said, okay, well. I said, okay. Then they showed me a picture of Miss Bosco. They said, do you recognize this woman? I said, no, sir, I don't. I said, oh yeah, that's right, because the last time you saw her, she looked like this. And they threw a picture down of her after she had been killed. Of course, that shocked me. I've never seen a dead body before, so it was very, very disturbing, to say the very least. And I can't tell you exactly how the interrogation went. I can tell you that at some point they put me in a corner, pinned my arms to the chair, started yelling at me, telling me that they knew I did it, that I must have done it. I was there. I need to tell them how to do it. I'm going to die. This is going to be a death penalty case. You will die if you don't tell us what's going on. At this point, I still told them I don't know anything. I started being poked in the forehead by Detective Ford while being pinned to the chair in a corner. The other detective that was there, I can't remember his name right now. I remember it starts with an H, but I can't remember. He was playing good cop with me. And he got Ford out of the room and he started to talk to me. He says, look man, I know you didn't kill this girl. You're not someone that would kill somebody. I know this. But we know you were there for the rape. We know you did it. We've got Joe Dick, and this is when I found out about Mr. Dick giving my name on. Said, Dick said you were there. We've got evidence that you were there. I said, but I wasn't. I couldn't have been there. It's like, how do you know you weren't there? I said, I was out to sea. I said, what? I said, yeah, I was out to sea. The day I believe it was the day I left for a 3-week cruise was when she was murdered. And they had told me that she was murdered at like noon or something like that. I said, well, I was out to sea. I know I couldn't have done this. So they came back and they said, no, you weren't out to sea because the murder happened at 5 a.m. Y'all left at 7. Well, at 5 a.m. I'm getting ready for work. So I couldn't have done it because, well, it's 5 a.m. I'm getting ready for work. I said, nope. They come back a little bit later and they say, no, it wasn't at 5 a.m. It was like 2 a.m. Where were you? At 2 a.m. 2 years ago on this day. I don't know. Probably asleep. 2 a.m. that's a pretty good guess. But you can't tell them exactly where you were. You can't give an alibi for that. Because honestly to me, the day didn't mean anything else the day before going out to sea. How are you going to remember something like that? The interrogation kept going. I can't give you timetables because honestly, it just doesn't stick with you. I remember at dusk, I asked to go out for a cigarette. I was beaten, I was broken, I was done. I needed a smoke. And the good cop went out with me. Sometime after that, I remember trying to go home. I said, look, I think I need a lawyer. I want to go home. I walked out of the interrogation room because at this point there was no one else in it but me. And I remember being ushered back into the interrogation room and being locked in. That's when I asked for the lawyer. But apparently I didn't ask for it properly because saying I think I need a lawyer apparently doesn't count. They started feeding information about what had happened. They asked, how did you get in? I don't remember exactly what I said because honestly I haven't read the confession in years. But I do remember that they changed drastically from being let in to breaking in with a crowbar to breaking the door down with your foot like in a movie. And this is through the course of everyone's confessions. Everything changed as the cops decided the stories were different. It's like you said, you just got to be there to actually understand. It doesn't make sense. I'd always felt that if I had been raised a little different, maybe raised in a city situation where I didn't trust the police, where I didn't believe they were our friends, that things would have been different. But Mr. Santana here is proof that being raised in a city doesn't change that. There's just a real problem with something. In my case, I believe it was Detective Four who was the problem. That's really all I can tell you about the interrogation techniques. I'm sorry. If you'll have any questions, I know I'm more than happy to answer any of Mr. Santana's questions.
I think now's actually a very good time for us to process that information. We have a break scheduled between now and 10:45 and 11 o'clock. They will be here throughout the rest of the day. You'll hear more of their story. You'll get a chance to interact with them. I just want to say one thing, and that is these stories that you've heard today should be Exhibit A for any legislation requiring the police to record interrogations from the beginning they bring a suspect into the station until the very end. And to this day, both New York and Virginia have resisted efforts to require recording. It's time to make a change. Thanks.